those who listened to him that he was screaming for help before he knew that that was being recorded. We can have an argument that he's this new cop wannabe who would know that it's going to be recorded, but the reality is the first person on the scene he told it to, the second person on the scene he told it to, the officer, that's Manalo and the officer, and he has the undeniable injuries that evidence nothing other than a violent attack by Trayvon Martin. There is no other reasonable hypothesis that could come from that undisputed evidence other than my client was attacked by Trayvon Martin. Some form of fashion. Is it determined quite yet how, in what precise moment? Maybe not. I would suggest that there is absolutely no evidence to contraindicate what my client now has before you and before the jury, which is that he was at the T intersection when he was approached and then attacked by Trayvon Martin. So there's no evidence to contraindicate that. And that he was hit in the face. And there's no evidence to contraindicate that. And that it did what we all know now it did to his nose. That violent act, in and of itself, I would suggest to you, is sufficient for immediate response with deadly force. But he didn't. What we have is 40 seconds of somebody screaming. Of course, you know, my client, through his statement, said it was him screaming. 40 seconds, and receiving additional injuries consistent with, and even the state's own experts said it was consistent with my client's head being bashed against concrete or hit, contacted, without using the emotional word of smashed, against concrete at least several times. That type of injury, in and of itself, the way it was presented by my client, that injury and the ongoing nature of that injury supports the right of my client under 776 to reasonably believe that he is in fear of future bodily injury because it was ongoing. The state's own witness, Captain Carter, said one really good indication of future bodily injury is when you've already been injured and it's still ongoing. You can presume that it's going to continue to occur. And that is, in effect, why my client acted in self-defense. And there is nothing, most importantly, under Walker, there is absolutely no interpretation of the state's evidence which excludes that as a reasonable hypothesis of innocence. And if you read Walker, the very words that I said, but the whole case is quite instructive. It allows for no other determination that since my client now has presented self-defense through the state's case, but it is now affirmative evidence of why he acted and the way he acted, that since the state cannot exclude a reasonable hypothesis of innocence based upon their circumstantial evidence, that the judgment of acquittal should be granted. That's under Walker. Walker also cites Woods, and it is the Woods case, which also cites another Supreme Court case, which is Barwick, B-A-R-W-I-C-K. Barwick case is 667 2nd 685. In 1995, Florida Supreme Court case, it also sort of began the premise in Florida law that the judgment of acquittal is appropriate if, in fact, the state fails to present evidence from which the jury can exclude every reasonable hypothesis except that of guilt. You, as Barwick says, Barwick again is 667 2nd 694, Barwick tells us that you at the outset have to determine whether or not there is competent evidence from which the jury can infer guilt to the exclusion of all other inferences. I would suggest to you that this would be a textbook case. It wouldn't make it to a textbook because it is so apparent from the evidence presented at this stage of the proceedings, judgment of acquittal after the close of the state's evidence, that the inference of non-guilt is much stronger than any suggested inference of guilt. Barwick, Woods, and Walker stand without question and unassailed for this proposition and should be considered by the court as to the circumstantial evidence issue. There are other cases that I would cite for you, and you have them in front of you. Sims is a 2013 case, 110 Southern 3rd 113, talking about the state's obligation to eliminate any reasonable hypothesis of innocence, and upheld that the judgment of acquittal in Sims should have been granted, and in fact, again, was upheld. And in that case, it also cited to law, State versus Law, LAW 559, Southern 2nd 187. And again, all of the cases that I'm citing to you, Your Honor, you have before you, although there are some of the cases, and I believe law is one of them, since it was cited in Sims fairly well. You don't have that actual case in front of you, but the site is quite specific. The STIEH, S-T-I-E-H, versus State, 67 Southern 3rd 275, was an interesting case for the court to consider. That's a second DCA case that's been out for a couple of years, where it was a stabbing, and the defendant argued self-defense and an ag battery, and the second DCA advised the trial court that it should have granted the motion for judgment of acquittal once the defense had provided or presented a prima facie case of self-defense. Now, I don't know if you believe that he has or not, so I have to argue both sides of it. I believe that the court should consider, and in fact should decide, that my client, through his statements over the last week and a half as they were presented, not only his statements, but all the supportive or corroborative evidence, and those are all of the witnesses, that my client has in fact presented a prima facie case of self-defense. And I mentioned it a moment ago, but just to make sure that the foundation is properly laid, we have my client's, if we set aside for a moment, I'm going to ask you to set aside for a moment that my client is just the most amazingly competent protector of his own murder. That, set that aside for a minute, that he didn't just decide as some snap decision to become a murderer and then was perfect in covering up everything. Because I would suggest to you that that is a fallacy of absurd proportions, that such could even be suggested by the state, certainly considered or actually endorsed by you. But if we set that aside for a moment, then what we have to look at is my client gets in the altercation with Mr. Martin. After following him to see where he went, as he agreed to with the officer, by not following him after he was told not to by dispatch, and to date, and the state's case is now done, to date, they have not presented any direct evidence, and I would suggest not even circumstantial evidence, that my client followed him after being told not to by the dispatch. They have no direct evidence, no circumstantial evidence that my client ever moved from the T intersection down the dog path until he was drugged or forced there by Trayvon Martin. There's not a scintilla of evidence to support that. There was, it seems, by Miss Bahador, at some point, though I would suggest it was highly incredible, that she suggested that for the first time she came up with the idea that maybe somebody is moving left to right. I'm sure you recall that. May well have been Trayvon Martin coming back for the attack. We don't know, but to suggest that that somehow inculpates my client to being the one moving is a stretch that I would ask that you could not consider making. It's certainly not one that's supported by any other corroborative facts or evidence. And of course, I think Ms. Bahador sort of came across, well, let's just say she came across as she came across by the time we were done with her testimony. But aside from that, there was nothing to support that my client did anything to re-engage or to engage Mr. Martin whatsoever. So if we're going to set that foundation, that that is what he did and didn't do, and then see what the foundational evidence is to support that, we have Jenna Lauer Jeremy Weinberg didn't testify. He was the woman, and so he was the fiancé with Jenna Lauer. But Jenna Lauer testified to something that, again, without my client's knowledge, completely supported what he said and how he said it happened at the T intersection. Even Ms. Sudaika, who thought she saw something, and I think thought she heard something a lot different than she saw or heard, through an open window or a closed window, whatever, still supports my client's contention that the altercation began down by the T intersection. Of course, the Manalos also do that as well. So without having the benefit of any of that testimony, we know that my client, of course, gave all that information to both Officer Singleton and Serino at a time when he had no information that any of that was available. Much more importantly, he had no information that any of that was controverted. Because had any of that been controverted, I'm sure that the state will well have brought that out to you before the end of their case. So we have Lauer, we have Sudaika, we have Manalo. We actually even have Mora, who documents my client's hypothesis of innocence or his prima facie case of self-defense. And that is, as she says, when she sort of wandered around the courtroom to look over the column to say that she saw my client on top of Trayvon Martin. A statement that he had already given to Singleton and Serino before he knew that this witness would be able to come out and say he or she saw anything. But he stated exactly what he did, that he moved the hands out. I think giving Mr. Bauer, Dr. Bauer's testimony would certainly support the idea that even having moved the hands out, as Ms. Mora said, the feet still move. Dr. Bauer seemed to say at some point that maybe the body can move, maybe it can't, but nonetheless, this is the foundational evidence for which you have to make a determination. Did my client present to date a prima facie case of self-defense? One, and two, is that prima facie case of self-defense and its reasonable hypothesis of innocence, which is, of course, what it is, specifically contradicted by the state's case. And under Walker, Woods, Barwick, and now, as I've mentioned to you, Stieh, S-T-I-E-H, they have failed to do that. So if we look at Stieh, which is interesting, out of the second DCA, and I don't know that I quoted it, apologize if I have already, 67 Southern 3rd 275, stating that the JOA should have been granted once the defendant had presented a prima facie case of self-defense. And it goes through a pretty good analysis of 776. In that case, they were talking about defense of others, but of course the same standard applies as we have here today. Jenkins, I think, is one of the most instructive cases. That's cited at 942 Southern 2nd 910. The reason why is because Jenkins, a 2006 case, remember, as an aside, that there are not a lot of cases about judgments of acquittal in self-defense cases after 2006. The reason why is, of course, we now have self-defense immunity hearings as an alternative to judgment of acquittal arguments in a trial. We did not avail ourselves of that pretrial determination of immunity. So many other people in most of the other case law have. So you'll see a significant drop-off in the number of JOA arguments or JOA appellate case law after 2006 on a self-defense issue because, as you would imagine, most of them exist pre-trial, they're addressed pre-trial. We had made the voluntary decision not to do that. But Jenkins, what Jenkins is good for, Your Honor, is that, first of all, the facts are close. Jenkins was in his house. A guy was outside making a lot of noise. He went outside. Jenkins did try to minimize the altercation. Cesaro, who was the eventual victim in the case, made a maneuver towards him, punched him in the face, wobbled back, goes Jenkins. Then the assailant comes again. Jenkins takes out a knife, catches